Hello, I'm Patrick Thomas, and welcome to Ladder Talks. This is a special edition Arkansas statutes. Yes, a lot of you following the Jacksonville City Council issue have got a lot of questions. I figured I would just bring it to you. I've got statutes here that are titled Chapter 42, Government of Municipalities Generally, Removal of Certain Elected Municipal Officials. Many of you have been asking about that. Removal of elective or appointed officers. Let's see, this one here is Title 21, Public Officers and Employees, Chapter 8, Ethics and Conflicts of Interest, Subchapter 3, Code of Ethics. And I'm going to come back to each of these. Chapter 52, Corruption in public office. Let's see here. That's 42. We'll put that in there. 52. Chapter 52, Corruption in public office. 5-52-101, Abuse of Public Trust. So let's put that one in here in 101. Chapter 52, Corruption in Public Office. Attempt to influence a public servant. That's 5-52-105. So let's see here. That's 105. That's 107. Got these in a pretty good order here. 1442, 109, 119. All right. Now, I'm not going to read all this to you, but I will. If you want to take a moment, get you some paper. If you're watching this after I've already posted it, pause it, get you some paper and write this stuff down. Research it on your own. You've been wanting to know a lot of the how-tos. I'm here to tell you it's all right here in the Arkansas statutes. Title 21, Public Officers and Employees, Chapter 8, Ethics and Conflicts of Interest, Subchapter 3, Code of Ethics. The only part about this that I want to read to you is, actually, this may be one of the few that I'm going to read all of it to you. 21-8-303. Enforcement. A1. It shall be the duties and responsibilities of the prosecuting attorneys of this state to supervise compliance with this subchapter and to prosecute persons who violate the provisions of this subchapter. Number 2. However, the Arkansas Ethics Commission shall also have authority to investigate and address alleged violations of this subchapter. B. 1. In the event the prosecuting attorney shall fail or refuse to enforce the provisions of this subchapter when the facts are known by him or her or called to his or her attention, any citizen of this state may bring action in circuit court to force. I find it interesting, folks. I'm going to read that again. any citizen of this state may bring action in circuit court to force compliance with this subchapter. The citizen shall be entitled to receive reimbursements for expenses and reasonable attorney's fees upon the successful outcome of such litigation. Now, I didn't really set out to suggest to you a change in this right here. But my thoughts are, if there is enough public outcry, that number two should not have to be an investment upon the citizens. Number two, I'm going to read it to you again. The citizen shall be entitled to receive reimbursements. Folks, we shouldn't have to put up any money at all. If the prosecuting attorneys don't want to do their job and we have to uprise as a citizen body to force compliance, and perhaps it ought to be in such a way that we do a petition to force compliance. If it was just, let's just say me and one other person, that's not much of a public outcry. Just because we say we got 50, 100, 1,000 people behind us doesn't mean diddly. But folks, I'm telling you, these statutes were written to protect the cronies. Yes, you heard that right. These statutes in Arkansas, all laws were written to protect not the citizens of the state of Arkansas. These statutes are written to protect their cronies. Let's just get that out there right from the start. Political buddies. If it's not to the benefit of the prosecuting attorney, him or her, if they refuse to enforce, okay? Now, I really want to go down a rabbit trail with refuse to enforce. But I'm going to come back to it. There are some things that officers of the law and elected officials choose to not do. They choose to use their discretion, and they refuse to enforce some things. If we enforced everything, we probably wouldn't get nothing done, and we probably wouldn't be enforcing the laws that we really need to be worried about. Now, in days and weeks to come, you're gonna hear me talk about something that I'm working on on the subject of refuse to enforce. Chapter 42, Government and Municipalities Generally. 14-42-109, removal of, it says, elective or appointed officers. If the mayor, member of the city council, or any other elective officer of any city of the first class or second class or incorporated town in this state shall willfully and knowingly fail, refuse, or neglect to execute or cause to be executed any of the laws or ordinances within their jurisdiction, they shall be deemed guilty of non-feasance in office. If the mayor willfully and knowingly fail, refuse, or neglect to execute or cause to be executed any of the laws or ordinances within their jurisdiction. Members of city council, they shall be deemed guilty. Y'all go print this stuff out for yourself and read the whole statutes. Chapter 42, Government of Municipalities Generally. 1442-119. Removal of certain elected municipal officials. A person who holds an elected office in a municipality for a term of 4 years in a mayor-council form of government is subject to removal from the office by the electors qualified to vote for a successor of the incumbent. It goes on in here and it tells you how to remove certain elected municipal officials. When a petition requesting the removal of an officer under this section signed by a number of qualified electors equal to 25% is filed with the county clerk shall determine the sufficiency of the petition within 10 days from the date of the filing. This is where it outlines the removal of certain elected municipal officials. It's out there, folks. Chapter 52, Corruption in Public Office. 5-52-101, Abuse of Public Trust. A person commits the offense of abuse of public trust if the person solicits, accepts, or agrees to accept on behalf of any person, political party, or other organization any benefit from another person upon an agreement or understanding that the other person will or may be appointed a public servant or designated or nominated as a candidate for public office. We'll go down to number 4. Offers, confers, or agrees to confer any benefit upon a public servant or a person elected, appointed, or otherwise designated to become a public servant, although not yet occupying that position, and the receipt of the benefit is prohibited by this section. B, or actually C. Abuse of public trust is a Class B felony. When the benefit is $25,000 or more. Class C felony is the value of the benefit is $5,000 or more, but less than $25,000. Class D felony is the value of the benefit $500 or more, but less than $5,000. Class A misdemeanor if the value of the benefit is less than $500 or the value of the benefit cannot be determined. So even if there is no value of the benefit to be determined, it's Class A misdemeanor. Chapter 52, Corruption in Public Office. 5-52-105, Attempt to influence a public servant. This is rather short. I'm going to read the whole thing to you. It's just 2 paragraphs. A person commits the offense of attempting to influence a public servant if he or she threatens violence or economic reprisal against any person or uses deceit with the purpose to alter or affect a public servant's decision, vote, opinion, or action concerning any matter which is afterwards to be considered or performed by the public servant or the agency or body of which the public servant is a member. Attempt to influence a public servant is a Class A misdemeanor. Chapter 52, Corruption in Public Office. 5-52-107, Abuse of Office. A person commits the offense of abuse of office if, being a public servant or being a person elected, appointed, or otherwise designated to become a public servant, although not yet occupying that position, and with the purpose of benefiting in a pecuniary fashion or obtaining a sexual favor for himself or herself or another person, or of harming another person, the person knowingly, 1, commits an unauthorized act which purports to be an act of his or her office, or 2, omits to perform a duty imposed on him or her by law or clearly inherent in the nature of his or her office. B, abuse of office is a Class B felony. If the value of the benefit is $25,000 or more, Class C pretty much follows all the other stuff that I read previously. So, I really like one of the first things I read, 21-8-303, Enforcement. The Arkansas Ethics Commission shall also have authority to investigate and address alleged violations of this subchapter. Code of Ethics. Doesn't say that they have to, or that they can, or they can refuse, or choose not to. So, don't know what to tell you, folks. There it is. Y'all do with that as you wish. I've got a lot to do already myself. I'm Patrick Thomas. You heard it right here on Ladder Talks, live from Studio 25. This is September 9th, 2019. Thank you. Have a good day.